of the Senate Energy and Natural Resources Subcommittee on Public Lands, Forests, and Mining will now come to order. I appreciate each of you for being here. Today we're going to hear about the law enforcement activities of agencies with jurisdiction over public lands and examine whether it's time to return law enforcement on federal lands to traditional law enforcement agencies or simply delegate those functions to local law enforcement officials as originally envisioned under FLPMA, the Federal Land Policy and Management Act. This issue is of great concern to communities throughout the West, including many in my state and in neighboring states that have long struggled against the constraints imposed by vast federal land holdings that are especially prevalent in the western United States. Increasingly, these communities find themselves as targets of overly zealous federal law enforcement operations. In a twist, these operations are not undertaken by traditional law enforcement agencies, but rather by militarized criminal law enforcement agents of the proprietary agencies tasked with managing federal public lands, namely the Bureau of Land Management and the United States Forest Service. In recent decades, as the number of federal laws and of federal regulations, many of which function essentially as criminal laws themselves, have been proliferating. The law enforcement has become a growth industry within these federal agencies. The BLM and Forest Service have followed this trend by expanding their criminal investigative activities, often with unsparing results for those who happen to be unfortunate enough to fall into their crosshairs. Whatever sense this attempt might have made as an effort to enhance funding or an institution's prestige, it's incumbent on this subcommittee to ask whether combining resource management and criminal law enforcement has resulted in a profound disservice to both. Undeniably, our federal land management agencies have drifted far from their intended purpose. The stated mission of the Bureau of Land Management is, quote, to sustain the health, diversity, and productivity of the public lands for the use and enjoyment of present and future generations. Similarly, the mission of the U.S. Forest Service is to, quote, sustain the health, diversity, and productivity of the nation's forests and grasslands to meet the needs of present and future generations. Now, the authors of these mission statements could not have imagined year-long cloak and dagger investigations that use informants to capture undercover video inside private homes on private land. The authors of these mission statements would have recoiled at the very thought of BLM employees executing coordinated pre-dawn search warrants on homes in a private residential neighborhood. The founders surely would have had concerns of their own. And yet in the small town of Blanding, Utah, this is what happened during the last presidential administration. To be clear, these agencies' missions necessarily involve managing natural resources and nationally significant sites. But I fear that the BLM and that the Forest Service have expanded their operations far beyond this proprietary mission to include the exercise on private land of police powers that the founders expressly reserved to the states. I understand these problems have been festering for a long time and that they didn't start with this administration. In fact, I'm very appreciative of the work this administration has done with the help of some of our witnesses here on the panel today to correct some of the past problems and abuses within the BLM and within the U.S. Forest Service law enforcement agencies. I look forward to hearing more about the administration's efforts from Mr. Steed and from Mr. Perry. But just as these problems did not start with this administration, they also can't be expected to end with this administration. Because of the nature of executive action in our government and because of human nature itself, whatever good work this administration might do could quickly, easily be undone by a future administration, one that is perhaps indifferent or maybe even downright hostile towards local law enforcement, toward federalism, toward local control. To guard against this possibility, it's imperative that Congress, and particularly this committee, examine permanent legislative reforms to land management agencies' law enforcement authorities. Now, Mr. Perry and Mr. Steed have already provided valuable perspectives on this issue, and I hope that they will continue to work with this subcommittee, with the committee as a whole, and with Congress as a whole in our efforts to reform law enforcement on federal land, especially law enforcement on federal land by law enforcement agencies of those land management entities. So I do want to thank all of you for being here today. We're pleased to have a great panel, and I'll do some quick introductions, and then we'll hear your opening statements. So first, we'll hear from Mr. Tracy Perry, who is the Director of Law Enforcement and Investigations at the Forest Service, and then we'll hear from Mr. Brian Steed, who is the Director of Policy and Programs at the Bureau of Land Management, and also a fellow Utahn, who I'm glad to have here. Then we'll hear from my longtime friend and Utah State Representative, the Honorable Mike Noel, member of the Utah House of Representatives representing the 73rd District. Mr. Noel just got back from a trip to China and immediately hopped on a plane in Salt Lake City to be here with us today. So welcome, and I hope you got some sleep at least on the airplane. If not, our gratitude to you is that much more profound, and we appreciate your dedication, Mr. Noel. After Representative Noel, we'll hear from Mr. Jackson Brossi, Executive Director of the Navajo Nation Washington office. And then finally, we will hear from Mr. Paul Larkin, who's a Senior Research Fellow at the Heritage Foundation. So thanks to all of you once again for being here, and the interest of time, and to make sure that we've got time to ask and answer any questions. Please try to limit your remarks to 5 minutes, and your full written testimonies will be, of course, submitted and accepted for the record. We'll start with you, Mr. Perry. Thank you.
Good morning, Chairman. Chairman Lee, thank you so much for the opportunity to speak with you this morning. My name is Tracy Perry. I'm the Director of Law Enforcement and Investigations for the United States Forest Service. There are two things you're going to hear from me today. One is the unique law enforcement mission of the United States Forest Service. The other is the importance of cooperation and collaboration with our federal, state, local, and tribal law enforcement partners. The Forest Service Law Enforcement and Investigations Program is charged with providing a safe environment for public and employees, and as well as providing the nation's resources on approximately 193 million acres of National Forest System lands. Our program provides a highly visible, uniform patrol presence that educates the public and enforces federal laws and regulations essential to the effective management of National Forest System lands. We also provide special agents with complex criminal and civil investigations, including investigations related to wildland fire, timber theft, resource damage, illegal marijuana cultivation, and cultural resource protection. We recognize the critical importance of maintaining strong and mutually beneficial relationships with our federal, state, local, and tribal partners. Successful management of forest lands is simply not possible without effective relationships with our cooperators, communities, and the public. We have been reminded of this valuable lesson in recent times, as there have been occasions where these relationships were not as strong as they needed to be. Unfortunately, there have been instances where poor relationships have led to questions concerning law enforcement actions, mission priorities, and jurisdiction of Forest Service law enforcement personnel. We accept responsibility for our role in failing to maintain these critical relationships, and we have taken significant steps to change that. The most significant of those steps was the development of an MOU with the Western States Sheriff's Association. The MOU establishes a template for an operational agreement between Forest Service Law Enforcement and Investigations and county sheriffs, and it can be utilized to define operational procedures and establish protocols for cooperation. Even more importantly, the collaborative process utilized to develop this MOU has vastly improved communication and trust. We currently maintain nearly 500 cooperative law enforcement agreements with our federal, state, and local partners. Over $5 million in funding is provided through these agreements to our cooperators. Many of these agreements also confer state authority to our law enforcement agents and our law enforcement officers. We have taken additional steps to improve our program. Last week, we released our strategic plan for 2018 through 2022. This plan will help increase efficiencies, prioritize work, and ensure that LEI activities are aligned with the mission and priorities of the Forest Service and the Department of Agriculture. A key theme of the plan is the emphasis on the natural resource law enforcement mission of our organization. Prioritizing work activities that are essential to our mission will also help focus our limited resources. Finally, we have established an Office of Professional Responsibility to help ensure that we continue to maintain the high levels of professionalism and integrity expected of a law enforcement organization. Establishment of the Office of Professional Responsibility will increase transparency, accountability, and responsiveness to elected officials, cooperators, and the public we serve. Mr. Chairman, that concludes my testimony. I am happy to answer any questions that you may have.
Thank you, Mr. Perry. Mr. Steed.
Good morning, Mr. Chairman. I, like you, am happy to be seated here with my Utah friends today, and it's always nice to be seated next to Representative Noel. I'm Brian Steed, the Bureau of Land Management's Deputy Director for Policy and Programs. Thank you for the opportunity to discuss BLM's law enforcement program today. The dedicated men and women who make up the program play an integral role in ensuring public safety and fulfilling the BLM's multiple-use mission. Nationally, the BLM manages a wide variety of resources spread over 245 million acres of public lands and over 700 million acres of subsurface mineral estate. These public lands and resources include timber, forage, energy, and minerals, recreation areas, archaeological sites, and many others. Under the Federal Land Policy Management Act of 1976, the Secretary of Interior is authorized to stand up a law enforcement body to enforce federal laws and regulations with respect to public lands and their resources. As a result, BLM has been given specific resource protection and law enforcement responsibilities that further its multiple-use mission. While the BLM law enforcement rangers and agents have accomplished important work protecting public lands and resources, the law enforcement program itself has experienced a number of challenges in the recent past. These challenges include very serious allegations of employee misconduct, including destruction of records requested by members of Congress, mishandling of evidence in criminal investigations, and misappropriation of government funds, among others. This behavior shocks the conscience and is entirely unacceptable. Moreover, these actions, in some cases perpetrated by a small number of individuals, have prevented the BLM from living up to the expectations of the American people. In the short time I've been in my position, the BLM has taken a series of actions to begin addressing these problems. Over the past several months, for example, the BLM law enforcement program has directed officers to focus on casework with direct ties to public lands, such as curbing the resource and public safety impacts generated by cross-border smuggling activities and reducing theft of mineral materials, archaeological and historical objects, timber and forest products, and other resources. BLM law enforcement has also made a concerted effort to improve working relationships with partner organizations, including the Western States Sheriff's Association, which is composed of sheriffs and their command staff from 16 Western states. As part of this process, the BLM is also analyzing the benefits of moving our law enforcement program to a location in the West and is evaluating whether it should be restructured to better fit organizational needs. These measures could potentially enhance interaction and communication with sheriffs on public safety and enforcement of natural resource rules and regulations. They could also better position BLM law enforcement officers for interaction with external user groups and other BLM staff, the vast majority of which are stationed in the western United States. Finally, over the past several months, the BLM has reinforced the need for accountability and professional ethics within the law enforcement program and has been diligent in taking administrative, civil, or criminal action in relation to conduct issues. For example, the BLM has significantly increased staffing of the Office of Professional Responsibility to help ensure the thorough investigation of complaints of serious misconduct involving BLM employees, including law enforcement officers and managers. As stated earlier, the BLM takes allegations of employee misconduct, particularly those associated with its law enforcement officers, extremely seriously. We are committed to maintaining a professional program with only the highest ethical standards. Restoring the public's trust in the BLM's law enforcement program is a top priority of Secretary Zinke and this administration. The BLM is taking significant steps to make this goal a reality and will continue to do so in the months ahead. Thank you again for the opportunity to provide testimony today, and I would gladly answer any questions that you may have.
Thank you, Mr. Steed. Mr. Noel.
Thank you, Mr. Chairman. It's a pleasure to be here. I've given extensive testimony in my written testimony, which you can read. It outlines the event that you mentioned with Dr. Red's family and what happened in Blanding, Utah in 2009. One individual that I key my testimony on is apparently no longer working for the agency. I don't know the full status of his employment right now, but we're very happy to see that. The problem that I see, though, and you mentioned it in your initial statement, is the concept of federalism. And where my district, the largest legislative House district in the state of Utah, comprising 7 rural counties, made up of over 90% of federal land and a little small portion, 9 to 10% of private property, that area contains tremendous amounts of public land that is dotted with also state land and also private property. And so having law enforcement be the local law enforcement is what my testimony is about today. It's imperative, it's important, it's critical that we go back to the concept of the county sheriff. I was happy to hear that Mr. Perry and also Mr. Steed have interfaced with the Western County Sheriff's Association. Mr. Perry, in fact, has worked directly with my son, who's the past president of the Utah Sheriff's Association, so we appreciate that. However, in looking at what happened with this particular officer, the special agent in charge for Utah, Nevada, and Idaho, that should never have happened. It would not have happened under traditional law enforcement. With an elected sheriff accountable to the people in his community, with oversight by the state attorney general's office, with oversight by the state legislature, that would never have happened. Time after time since this employee has been in place, we went back to D.C. We talked to his superiors. We talked to the head director of the Bureau of Land Management, told him of these egregious actions by this individual, and we got nothing out of it, zero out of it. Now as you go back and you read the record and you see some of the things that he's done, particularly to one family that resulted in the suicide death of a well-known physician, a good friend, Dr. James Red, it's very, very tragic. My good friend Phil Lyman, who will now take my place in the legislature, we believe, because he is the Republican nominee for that position, was also subjected to this law enforcement actions. I would like to see further investigations into the BLM law enforcement and the actions that resulted. I would like to see those cases where people were prosecuted illegally be reviewed again, because in fact, if the evidence that was presented was done in a corrupt manner, if it was collected illegally, if it was done improperly, which we can see from the Wooten letter from his associate, then we should have an opportunity for them to go back to court. And therein lies one of the main problems that we have. When you break a federal regulation under the Federal Land Policy Act of 1976, you don't get a jury of your peers. You get a federal magistrate. You don't have an opportunity to defend yourself. And going to federal court And trying to defend yourself in federal court is a no-win situation. It costs hundreds and hundreds of thousands of dollars, and most people are willing to take a plea bargain with lesser charges just to get out of this system that's broken. And so I hope my testimony today, and I hope my testimony in the record, highlights the fact that the most important thing we can do is to go back to the concept that the county sheriff is the one that's in charge, that these law enforcement officers have proprietary jurisdiction. They do not have concurrent jurisdiction, and the state legislature has never given them exclusive jurisdiction for law enforcement on the public lands in the state of Utah. They should confine their law enforcement activities to the resources on those public lands. They should deal specifically with those. If it gets into an area or an arena where it involves state laws, they should not be able to assimilate our state laws and stop my citizens and my constituents on state highways. They should not be able to arrest them for not having their taillights on their cars functional. They should not be allowed to do anything that a state law enforcement officer, a duly elected sheriff by the people of that county, can do adequately. So I would appreciate further investigation, and I could provide additional information about how the FBI was involved with this too, and we need some more investigation into that arena with Mr. Love and an FBI agent. Thank you.
Thank you, Mr. Noel. Mr. Brasi.
Chairman Lee, thank you for the opportunity to present today on the law enforcement programs at the Bureau of Land Management and the U.S. Forest Service. My name is Jackson Brasi. I'm the director of the Navajo Nation Washington office, and I'm from the community of Red Mesa, which straddles the Utah and Arizona border. President Russell Begay regrets he cannot be here and has asked that I stand in his place. The Navajo Nation spans across 27,000 square miles in Arizona, New Mexico, and Utah. Our ancestral territory, however, is much larger, ranging from southern Colorado and radiating through the current boundaries throughout the Four Corners region, including the Chaco Canyon region and the Bears Ears region. These places are rich with the Navajo people's cultural resources. Accordingly, much of our ancestral land is now managed by the BLM and the U.S. Forest Service. In fact, 3 of our 4 sacred mountains are managed by the National Forest Service. The Navajo Nation therefore has a significant interest in how law enforcement is conducted on these lands. I'm here to discuss the importance of federal law enforcement and the protection of tribal resources in the Bears Ears region of southern Utah. Tribal artifacts have been looted in southeast Utah indiscriminately for decades. In 2009, after years of undercover work and coordination between the BLM and FBI agents, a sting operation on a multi-million-dollar black market tribal antiquities trade led to 19 arrests. The arrests were possible because of the work of BLM agents who curbed decades of unchecked stealing of resources in direct violation of federal laws such as NAGPRA, the Archaeological Resources Protection Act, and the National Historic Protection Act. Despite the federal crackdown in 2009, looting, grave robbing, and blatant lawbreaking has continued and is a problem today. Between 2011 and 2015, the BLM documented 26 incidents of cultural resource damage in San Juan County, Utah, and there were likely much more. During this time, the BLM has had only 1 law enforcement agent assigned to the Bears Ears area. I've noted there are several instances. I want to provide some examples of the instances that have happened since 2011. In 2012, campers tore down a 19th century Navajo hogan and used it for firewood. In 2013, looters desecrated a burial site at Butler Wash. And in 2014, a 2,000-year-old pictograph in Grand Gulch was vandalized. We've had reports of petroglyphs being removed from rock walls with chisels and saws. We've had reports of rock art being vandalized with people's names etched into the walls. 2,000 to 3,000-year-old materials being used to build fires. And we've even had reports of people using guns to shoot rock art off of canyon walls. We'd hoped the establishment of the Bears Ears National Monument would provide additional law enforcement personnel in the region. However, while we may not be able to stop completely the desecration of tribal, cultural, and antiquities, we will make active efforts to protect them to the best of our abilities. In summary, it is critical for federal law enforcement personnel to patrol and enforce federal law on BLM and U.S. Forest Service land. In America, we value the rule of law. Therefore, there should not be, we should engage in as much deterrence, and there should be consequences for crimes. As our trustee, we expect the federal government to work with the Navajo Nation and the other tribes in the region to protect tribal cultural resources on the nation's public lands. It's unacceptable that in 2018, federal laws continued to be broken with such disregard at such a high rate. We look forward to working with Congress on this very important issue. Okay.
Thank you, Mr. Brossi. Mr. Larkin.
Thank you, Mr. Chairman. The Los Angeles Times and my colleague, Representative Noel, have described what happened in Blanding, Utah. And based on what I have read, it seems to me that the tragedy that occurred there had at least 3 causes. One was the mistaken decision by a BLM special agent to treat Dr. James Redd as if he were Pablo Escobar, and to conduct an assault and takeover of the Redds' home as if they were members of a biker gang cooking meth. Now, that problem is not something Congress can fix. Congress can neither appoint nor train federal agents. But there are 2 other causes of that tragedy that Congress can fix. One is overcriminalization. It's a neologism that describes the phenomenon of the overuse, the abuse, and the misuse of the criminal law. One form that it takes is the use of the criminal law rather than the civil or administrative law as a predominantly regulatory tool. Now, the focus of this particular hearing may not be on overcriminalization, but it is at the heart of the problem here. I've written a great deal about this in my position at the Heritage Foundation. And what happened is a classic example, that is, what happened in Blanding is a classic example of what happens when we overcriminalize the federal code. The second factor is the government's decision to create criminal investigative divisions in proprietary and regulatory agencies. The problem with that is similar to the problem with the now expired Ethics in Government Act of 1978, a loss of perspective. General law enforcement agencies, like the New York Police Department in the city where I grew up, see the full range of conduct and can put in better perspective individual instances of misfeasance, malfeasance, and wrongdoing than agents can when they only have a narrow specialty to investigate. Why is that? Because federal law enforcement operates on the same type of body count method that we used during the Vietnam War to measure success. Federal law enforcement considers, particularly during the budget and appropriations processes, the number of cases opened, cases closed, cases referred for prosecution, arrests, charges, indictments, convictions, length of sentences, total amount of fines, and total amount of money that is forfeited to the United States. That is the standard measure of success. You know it better than I because you have to vote on the budget of federal law enforcement agencies. The problem with that is we are measuring outputs, not outcomes. We are measuring what is used with the dollars Congress gives to the agency and what the agents actually do with that. But we are not measuring what effect it has had on the communities or on the rate of commission of crimes in any particular area or in any particular field. That creates a problem. Agencies need to justify past budget appropriations and certainly have to justify even more future ones. Unless they can use statistics to make that case out, what you will see, unfortunately, are tragedies like this happen. Because a statistic in an important case on a sheet of paper shows up to be just as big a case as a small case, which means you can make 3 small cases and get 3 credits for it even though the cases are in fact quite trivial. Using the criminal law to enforce regulatory procedures, to enforce regulatory schemes, inevitably leads to that sort of problem, in part because the average person doesn't know what every regulation is out there. Most people don't know what the Code of Federal Regulations is, or the Federal Register, or where to find it. And that's just not me talking. That's former Supreme Court Justice Lewis Powell said that in an opinion for the court. If they don't know what the law is, they can't comply with it. And even if they make a mistake, it is oftentimes far better to use civil or administrative mechanisms than criminal to go after someone who has broken such a rule. The criminal justice system has a powerful effect on the society. I've been involved in the criminal justice system for most of my career, and getting arrested, getting charged, going through trial has an enormous effect. It should be reserved for the most serious crimes people can commit, not the sort of ones that were at issue in the Blanding tragedy.
Thank you all very much for your testimonies. We're now going to start a series of 5-minute rounds of questions, and I appreciate you being here for those. Mr. Steed, let's start with you. Tell me, if you can, what law enforcement functions your office performs that could not be accomplished just as well, but perhaps with a greater degree of discretion and concern for local communities, by a combination of local law enforcement and traditional federal law enforcement agencies?
So, Senator, I appreciate the question. If I'm understanding correctly, you're asking what we do that's different than anyone else?
Yeah. What do you do that couldn't be done just as well, or perhaps in some ways better, by a combination of local sheriffs and, as necessary, the FBI?
It's a difficult question to answer, and I'll tell you why. FLTMA, under the Federal Land Policy and Management Act, gave discretion to the Secretary to stand up a law enforcement agency within the BLM, specifically to enforce the those items in FLTMA that are addressed. That's been added on to in the time since through the Archaeological Resources Protection Act, Native American Graves and Repatriation Act, Protection and Repatriation Act, and others. And I think by default, based on our proximity to the land, we've been tasked with doing those jobs. As to whether we are unique within the law enforcement community to do it, I don't have an answer for that, besides to say that I think that in enforcing federal law, generally based on jurisdictional issues, federal law enforcement would be tasked rather than state law enforcement unless they went through the perceived training that's required to be qualified as a federal law enforcement.
And yet nothing in federal law precludes them from using local law enforcement, and in some ways it encourages it. It at least acknowledges it as a legitimate alternative that should be used unless there's a reason not to.
And to that extent, we rely on a number of contractual relationships with local counties as well as other local law enforcement agencies to involve local communities as much as possible.
Okay. Mr. Perry, how would you answer the same question?
Thank you, Chairman Lee. What I would say to that question is that the Forest Service, we have a unique law enforcement mission, and we have unique training and skills related to natural resource law enforcement that is unique to our agency. Wildland fire investigations, timber theft investigations, illegal marijuana cultivation related investigations, cultural resource protection investigations. We're the best in the world at that. We train specifically to those things, and I think that differentiates us from our other federal, state, and local partners. We work collaboratively with them on public protection and protection of the public in a lot of ways, but those specific skills are unique to us.
And yet local law enforcement authorities are not strangers to cases involving theft, to cases involving arson. Surely you're not describing them as inadequate.
I think that the training that we provide specific to wildland fire investigations, cultural resource theft violations, I just think our training it's a very complex, many of those investigations are very complex. And I think it takes a lot of training and a lot of specialized experience to be successful in prosecuting those types of cases.
Mr. Noel, could the local law enforcement authorities in your district, the largest legislative district in Utah that includes, what did you say, 7 counties, right? Could the local law enforcement officials in your district handle most functions or duties performed by BLM law enforcement?
Yes, they could, and I'm not just relating that directly to just our local law enforcement, because our local law enforcement is also tied in with the state. It's tied in with our Attorney General's office. They work very closely with the DEA, and so when we talk about marijuana growing, our local law enforcement is very, very involved with that. They rely heavily upon the local people in that area to report marijuana growth, to report the things that are happening, because those are the people that are out on the land. So it's important that we have that relationship with them. And I don't necessarily disagree with Mr. Perry that they've had some extensive training, but in effect, a lot of the BLM officers don't have the type of training. Our law enforcement officers we get this idea that it's Barney and Andy law enforcement. It's a whole different situation now with millions of visitors visiting the public lands. Our law enforcement agents are trained very, very well. They do a lot of drug interdictions. They deal with things that happen on the public lands now, with rape, with theft. All those things happen. They're all prosecuted in our offices. And I don't think that the BLM nor the Forest Service agents have that type of training. I just don't think that's what it is. They do have resource training. I agree with that. And timber management and fire suppression, those things, I think they can do a good job there. As far as the archaeological theft, we have the help of the State Historic Preservation Officer. Even the federal agencies have their own archaeologists who work closely with the SHPO within the state of Utah. So again, we have the Native American Liaison Committee in the House which works with the Native American. I myself have passed numerous laws on the Utah Native American Graves Repatriation Act. Just this last 2 sessions ago, I passed a law that allowed for any remains to be buried on state park areas and set-aside areas, because the Native Americans in my area want them to be buried as close as possible to where they find the remains. And if those are on private property, if we can move those remains to an area in that locality, they would prefer that. That was accepted by the Native Americans. And so I appreciate Mr. Brosi and his comments, but again, we do consider grave digging and grave robbing as a very serious crime. We do respect your culture and respect the fact that we shouldn't have people out digging on those lands. That was not the case in Blanding. We can go into that in great detail, but that was not the case that occurred. There were 26 people that were arrested, and I believe there were 2 people that plead, and no one really served any time. So it was 140 law enforcement agents that came in the community. They could have had a citation and a request to appear in court, and they would have all appeared in court. It was an overkill by the federal agencies. Even the federal agencies themselves said it was an overkill to go through that and to do the type of tactics that occurred there. And this is what's happening with federal law enforcement, Mr. Chairman. There's this buildup and this militarization. The weapons and things that they use now, automatic weapons, fully automatic weapons with police dogs and with tactical gear, it's not necessary. It's intimidation, and it's inappropriate for a rural area like my district.
And if the BLM law enforcement or Forest Service law enforcement were to enter into agreements with your local law enforcement officials, wouldn't those local law enforcement officials be willing and even eager to work with them to make sure that the law was enforced within their jurisdiction?
They absolutely would, and they would be willing to be trained, and I think it would save the taxpayer a tremendous amount of money. The differences in pay scale between local law enforcement and state law enforcement and federal law enforcement are astronomical. It's a federal law enforcement officer is in excess of $100,000 a year, whereas a state or a county law enforcement officer is somewhere around $45,000 to $50,000 a year. So with contracts, I think we can do a better job. We have a better connection. It's no different than on the Navajo Nation or on the Paiute. They have their own law enforcement people, and they work with their own people, and it's be the same thing. I understand these are ancestral lands, but they're also lands where people live, and it's part of our state government. The elected official in San Juan County, Rebecca Bonelli, she is responsible partially for the funding of law enforcement within that county and working with the local county sheriff. If there are problems there, she is the one that can actually say, we need to work on this more. So again, the training is there. We're much more sophisticated. It's not just one sheriff. It's the Utah Sheriff's Association. It's the state of Utah. It's the Attorney General's office. But again, it goes back, Mr. Chairman, to the concept of federalism, and we feel like we can do better as a state in managing our law enforcement affairs than the federal government.
Mr. Steed, Representative Noel makes a good point, especially when you consider the differences in the pay scale. And we're not talking about a slight difference there. That's a very significant difference. If you could, in fact, get as good of an outcome, perhaps even better, for something that he describes as, in some cases, maybe even less than half of the cost, why wouldn't you do that? Especially given how much money that would save for you, that you could put into other things you do within the Bureau of Land Management to make sure things are well maintained.
And Senator, we're happy to take a look at that. I'm certainly not saying no. What I would say is we're already engaged in a number of contracting arrangements with local and law enforcement agencies. I provided you a letter earlier today, at least I provided it to your staff. I hope it filtered up to you. Sorry for being a little slow.
Better late than never.
Better late than never. Detailing those arrangements that we have ongoing, and we're proud of the work we do jointly with local law enforcement. I think to answer your question, though, the one question that we have to address is whether or not we'd have to send local law enforcement officials through the Federal Law Enforcement Training Program, or FLETC, and that's an open question that's never truly been addressed. In order to be federal law enforcement officials or qualified in enforcing those federal laws. To date, that's been the standard, and we haven't been, to my knowledge, we haven't been approached by local sheriff's office asking for that authority. So it's something we can look at, but I think there are open questions there.
Mr. Perry, same question.
Yes, Mr. Chairman. I think, we work very well with our county partners. We value them. I mean, the sheriff, we recognize the sheriff as the supreme law enforcement official in the counties they serve in, and we want to work collaboratively with them. We just feel like our missions can work in conjunction with each other. As it relates to the training and the ability of them to do our jobs, currently the Forest Service doesn't have a mechanism to confer federal authority onto our county partners. And most of the sheriffs that I've spoken with don't have an interest in enforcing federal law anyway. They would prefer to handle crimes that occur on National Forest System lands through their authorities of the state, which I think is certainly appropriate. The Secretary has to have the ability to enforce rules and regulations that he promulgates. And the concern is that if there is no law enforcement mechanism within the Forest Service, then how does that get accomplished? Again, I think that working collaboratively with our partners is exactly the way to go. I spend a lot of time traveling to the West to make sure that those relationships are strong. I've developed a lot of great friendships with the county sheriffs and the Western State Sheriff's Association and the National Sheriff's Association. And again, we recognize them for their authority and what they bring to the table. They're essential. We can't do the job without it. We have roughly right now, about 613 law enforcement personnel for 193 million acres of National Forest System lands. There's absolutely no way we can do that without their support.
Mr. Steed, can you tell me about how many BLM law enforcement officers have been fired upon in the last 5 years?
That information is contained in the letter. I don't have it in front of me right now. There is a number of people who've been fired on.
A number, but
I can't remember the exact. It's
single
not
digits?
Yeah.
Okay.
It's not a huge amount.
Okay, so very rarely. If it's in the single digits, we're talking about no more than 1 or 2 a year.
Although if you're the law enforcement officer receiving fire,
I understand that.
Certainly becomes a bigger
understand
deal.
that. Very, very serious. But it is nonetheless important to keep that number in mind. How many traffic citations have BLM law enforcement officers issued in the past year?
And again, that number is contained in the letter that we submitted to you. I don't have that in front of me. It's a lot. I mean, it's
More than 5 or 10?
correct.
Are we talking hundreds?
Let me see if I've got those numbers in front of me. I may. You know,
I do have them. You submitted the letter this morning, but
and I apologize.
just moments before the hearing, so I didn't have a chance to go through it
absolutely.
yet. Or we're talking about thousands,
It
right?
could be, correct.
Okay, but we're talking about thousands of traffic citations being issued every year. And yet in the last 5 years, you can count, maybe 5 times in which a BLM law enforcement agent has been fired upon. So given that profile of activity, why are armed BLM law enforcement agents wearing flak jackets, no less, executing search warrants in the private homes of artifact collectors?
So we've been charged through our mandate to enforce federal law. Part of that federal law is archaeological resources protection. I believe that the case you're referring to the case has been referenced previously. Is that accurate? Which was a multi-year effort, is my understanding, which yielded 14 search warrants, 27 indictments, 12 felony convictions, 5 misdemeanor convictions, and 10 collections served or seized, 10 collections seized of illegal artifacts. We currently have those artifacts in a warehouse that we're working diligently to repatriate those. It was a large operation. So as to tactics and approach, I'm not here to defend tactics taken. I can say that one of the things that we're doing in terms of our review is a uniform rules review. We specifically want to look at the necessity of those external flak jackets. In some cases, they may be well needed, especially in our operations along the southern border. But certainly that shouldn't be how we present ourselves on a day-to-day basis.
Is there any reason why that warrant had to be executed in the manner it was, why the raid had to happen in the way that it was, and why it had to be done by these specialized federal law enforcement agents within a proprietary federal agency?
And again, this is before my time, and unfortunately, I don't know the details of why they decided to execute the warrants in the manner in which they did.
Mr. Noel, in your opinion, based on what you know about that instance, would local law enforcement have carried out the same procedure the same way?
No. In fact, I talked to numerous individuals in the legislature, several of which have a history. One was a federal or a state judge, and just uncalled for. That type of an action was uncalled for. They could have easily have asked people to appear. They had the evidence. There was no reason to go in the middle of the night. If you read my full report and what happened, and also, again, with the OIG report, you'll see what an extreme measure to have snipers on top of the Red's roof and to hold him for 6 hours in chains. When he went in to use the restroom, to have 2 agents at one knee and make him use the restroom and not even allow him to clean himself. To do those types of things is dehumanizing, humiliating. If you go back and you talk to the Native Americans in that area in the many, many years that Dr. Red served them, their families, their children, delivered babies, he was very well loved there by both Native Americans and by the Caucasian community in that area. And so it was just uncalled for. And it has had severe ramifications on the family. And it was an incident that should never, ever happen again. Again, I do not condone in any way, shape, or form of going in and digging into Native American graves. I think that is highly inappropriate. And I think I strongly believe that anyone that's in a law enforcement capacity would stop that from happening, and people would be prosecuted for it, whether civilly or criminally, I don't know. But that case was definitely something that should not have happened in that manner. And if you go back and you read this Mr. Love, and with his kill list and with his statements, you had a very deranged person in charge of this agency for many, many years. We tried to point it out, and prior to Mr. Steed, that fell on deaf ears, on his supervisor, on the head of the agency, and this is the result that you have now and what's happened and transpired since then. And all the information is now coming out. We need to investigate this further because he didn't do it on his own. He was complicit with other federal people. In one case, in my discussions with a retired FBI agent, over 2-hour discussion, and 2 other individuals relayed to me this individual, when he first started to work for the agency, these characteristics were coming out in the very, very beginning, and it's a very sordid affair that went on between him and another FBI agent. That needs to be investigated, Mr. Chairman.
If someone like him had been employed with the local law enforcement agency, I would imagine the outcome would have been different.
It definitely would have been different. There would have been more oversight. This is one of the things that we don't hear. Who dispatches BLM? They're dispatched through the county. They work with county dispatching. Who does the search and rescue portion of it? The county does that. So as Mr. Perry said, and also Mr. Steed said, the county is actively involved in all of these issues. It's just a matter of, again, it goes back to the federalism, the proprietary jurisdiction that the agencies have as opposed to exclusive jurisdiction, which is well set out in the Constitution of the United States and the concept of federalism. With the concurrence of the state legislatures, they can have exclusive jurisdiction or concurrent jurisdiction. But in this case, it's proprietary. And I would say to you, Mr. Secretary, under Section 303, Part C, when the Secretary determines that assistance is necessary in enforcing federal laws and regulations relating to public lands or their resources, he shall offer a contract to appropriate local officials having law enforcement authority within their respective jurisdiction with the view of achieving maximum feasible reliance upon local law enforcement officials in enforcing such laws and regulations. Now, whether that requires some federal training, I don't know, but it certainly seems to me, and the fact that it's laid out specifically in Flipman 1976, that they highlighted that they would have a uniform Desert Ranger force in the California desert, and for the first 10 years of the agency of BLM, we had no Rangers. They were only in the California desert. Tells me that the intent of Congress in that law was not to have federal law enforcement agencies using state law, arresting people for traffic citations, arresting people for crimes such as rape and murder and other crimes that would normally be done by a state and should be done by a state. If you were in New Jersey or Delaware and someone came up to give you a traffic citation and you didn't recognize the uniform and he told you, well, I'm a BLM agent and I'm not even on federal land. I'm in your county on private property and I'm issuing you a citation. And that has happened. Anyway, I'm sorry to go on, Mr. Chairman.
No, thank you. That's helpful insight. When I was a teenager, I was a big fan of a movie called Fletch. In that movie, the lead character, played by Chevy Chase, claims at one point falsely to be part of the federal mattress police. And he instructed someone that he was speaking to that they should be concerned because the do not remove tags on the mattress had in fact been removed when they weren't supposed to be. And I've thought many times since then, it's very fortunate that we don't have a federal mattress police, in part because of a law enforcement agency with such a confined, narrow stovepipe into the world, such a confined, precise mission, would look around sort of like the person holding a hammer to whom everything looks like a nail. And all they see is perhaps opportunities for a raid. If that's all they're focusing on is enforcing the do not remove tags and the laws applicable to mattress tags, then perhaps everything would be a raid complete with flak jackets and snipers on the roof. Mr. Larkin, you have witnessed some of these problems firsthand while at EPA. For those of us who haven't witnessed firsthand some of these problems, could you illustrate for us some of the perils associated with giving regulatory or proprietary agencies' law enforcement powers, particularly in a narrow-scoped area?
Sure. Let me give you an example of a case of my own, a case that actually happened here in the District of Columbia. I got a report that there was a business in the District of Columbia that was in the process of manufacturing glue, and they had illegally stored hazardous waste in the yard right outside. I went there, and in fact, it was all over. And if I had wanted, I could have wound up hooking up the woman who was in charge of the business, and she would have been charged, et cetera. But as I looked into the investigation, I found out that the business was actually run by her husband, who had died a few months before. She'd only been down there one time to find out what the business was doing, and while she was there, she got mugged. So she had never been back again and had no idea what was going on. And I decided this is something the civil people can handle. They can do the remediation. If they want, they can fine her civilly or administratively. But this is not the sort of person that we need to use to make an example of for the purpose of protecting the public health. The civil side could adequately do that. And in my office, all the other agents said, why are you doing that? It's a cheap stat. Now, I had a career before I became an agent at the EPA, and maybe that's why I didn't see any need to use that as a way of getting a statistic. But even in the environmental area, I think you have to make reasonable judgments. I mean, I had another case where I helped send to prison a physician who went down to a homeless shelter with the use of a dope dealer to get people at the homeless shelter doing asbestos rip and strip. He didn't give any training. He didn't give any protective gear. He didn't even tell them it was asbestos. Essentially, these people are all a manslaughter in progress because they're all going to die from the work they did. That's a very different case. This was a doctor who did this. He knew that it was illegal, and he knew the harm it would cause. That's the sort of person who you need to go after, whether it's an environmental crime or something else. But what we had here in the Blanding case seems to me just to be, unfortunately, an overreaction. Even if they thought the people here were involved in some great black market scheme to rob graves and do everything else, once they found out that that wasn't the case, they should have just ended it right there. The problem in federal law enforcement is once you invest all these resources, everybody wants something to show for it. That nobody wants to just close a case and get heat from their supervisors about spending all this time and resources and getting nothing out of it. You want to in on a secret? Take a look at cases where people have pled guilty to misdemeanors. It is not uncommon to find that where people plead guilty to a misdemeanor, it's because there really isn't much of a case there to begin with, but they needed something to show for it.
So it should not be the presumption that when somebody has done something wrong, that the only solution every time is always just criminal action. In many cases, it could be handled by a combination of fines, civil action, perhaps seeking an injunction in some cases, in other cases, civil monetary penalties.
I worked in the organized crime and racketeering section of the criminal division as one of the two offices I was involved in at the Justice Department. There are seriously bad people out there. We don't need to manufacture them.
Let's talk about the different jurisdictional situations in which different landowners find themselves. If we were talking about a private landowner has authority, obviously, to control what goes on, who enters and who doesn't enter onto his property and what they do there. Can ask people not to smoke on his property and ask them to leave if they don't do it. If they're misbehaving, if they come onto the property without authority, or if they come onto the property and disobey some request of the landowner at that point can ask them to leave. If they don't leave, they can call the police. But the private landowner is not normally someone we would think of as someone who can at that point slap handcuffs on the person and book them himself and then bring charges. Is that something we should take into account in looking at the fact that we're dealing with a land agency? I mean, I'm not necessarily talking about the existing structure of federal law, which does in fact purport to authorize the creation of these jurisdictions. But if we were looking at it as a matter of first principles on a blank slate, wouldn't it be appropriate in some ways to view this as being a distinction between a proprietary interest in the federal land and having a law enforcement agency enforcing violations that someone commits as a condition of being on that property?
You grew up in Utah.
Yes,
I
sir.
grew up in New York City. In New York City, we don't make landlords into the police, okay? We have a police department for that. And at a time, they even had a separate component just for public housing. It's now all part of the NYPD. We use local police to deal with local problems. In this circumstance, you could do, as my colleague, Mr. Noel, said, and use the locals to do it. Why? There are two types of knowledge you need to be an investigator. You need to know how to investigate a case, and you need to know what the law is. If the sheriff's department doesn't know what the special laws are, they can be taught those. And that's not going to take a long period of time. The Federal Law Enforcement Training Center probably could put the course together for them, and they might even be able to do it out in the different states in the West. After all, there is a federal law enforcement, at least when I was an agent, there was a federal law enforcement facility in Artesia, New Mexico. That's where I went to firearms instructor training school. So they could run a course there, even just to save on the costs of having everybody travel from all over. So that can be done. They could teach them what they need to know, because the essential investigative skills they already have. They learned those when they went through their state or local academy. So in terms of being able to acquire the knowledge necessary to enforce these laws, you know, putting aside that whole question of overcriminalization, but they can be taught that. But you also have another option. That's the U.S. Marshal Service. The U.S. Marshal Service is a federal agency. They go through the same criminal instructor training program at FLETC that the people from the Forest Service and the Bureau of Land Management do. It's the same course. FLETC trains everybody in that program with the exception of the FBI and the DEA. Even the Secret Service agents do, at least when I was an agent, did their first round of training at FLETC in the Criminal Investigator Training Program before they went on to Beltsville to learn protection. So the Marshal Service has been trained up in all the investigative skills. If they needed some additional knowledge of what the particular laws are, again, FLETC could offer that for them. The Marshals work with the locals all the time. And they, to my knowledge, when I was an agent, had a great relationship with the locals. Now, the Marshals, I think, are an underutilized law enforcement component in the federal government. They principally work to serve the courts. But historically, at least in the 19th century, they had general law enforcement duties in many places in the West. I'm sure they did in Utah. And in fact, the U.S. Marshals are still appointed by the president, so they're accountable, and they have to be confirmed by the Senate, so the Senate has room to play in deciding who becomes a U.S. Marshal. So there is that type of accountability. Plus, to the extent you can hold people accountable through the budget process, you have an advantage with the marshals that you don't with local law enforcement, which is you control the budget. You don't control the budget for the sheriffs in Utah, but you do for the U.S. Marshal, and you do for the Marshal Service generally, okay? And finally, to the best of my recollection, the Marshal Service, in the statute that creates them and empowers them, gives them the same sort of authority that the state law enforcement officers have. So they could, at least perhaps when they're working on a joint investigation, use whatever state law enforcement authority their counterparts have. And in fact, I think the Marshal Service can also deputize state and local law enforcement officers in order to exercise federal law. Now, I would ask the director of the Marshal Service for that opinion, or for somebody at DOJ to confirm it. But to the best of my knowledge, you can make people into essentially deputy U.S. Marshals, special deputy U.S. Marshals, particularly on a as-needed basis in a particular case. So, yes, my colleague talked about using state and local law enforcement, and state and local law enforcement might be one way to go. But I think another option to consider is using the Marshal Service. And since everybody at BLM and the National Park Service has already been trained, you could transfer the people, Congress that is, could transfer the law enforcement programs from agriculture and interior to the Marshal Service without even costing people jobs. So it's another option to consider, and to the extent that people are concerned that the Secretary of the Interior and the Secretary of Agriculture want to have their authority enforced, the Marshal Service is certainly going to be responsive to their concerns.
I appreciated what you said earlier about the overcriminalization issue, and noting that although that's not the precise focus of this hearing, it is closely related to the overcriminalization problem. It reminds me a little bit of something described in Federalist 62, which I believe was written by Madison, where he says, in essence, it'll be of little avail to the American people if their laws are written by those of their own choosing, if those laws are so voluminous and complex that they can't reasonably be read and understood, and understand what the law is today and understand what it will be tomorrow. And so how does this contribute then to your concern about these agencies, the fact that they are handling, among other things, a number of regulatory criminal offenses? Does that concern you?
Very much so. The very first Congress passed the first criminal law act in the United States and made about 30 offenses. All those were ones necessary to get the new government up and running. They dealt with the courts. They dealt with the inspectors for the Customs Service and the like. And they dealt with piracy and other things dealing with trade, because there was no income tax to fund the operation of the federal government. So it was basically through revenue from imports that the federal government got funded, as well as selling land later. Nowadays, there are so many criminal statutes, federal ones, that nobody knows how many are out there. The Justice Department looked, it couldn't find the answer. The Library of Congress looked, it couldn't find the answer. The American Bar Association looked, they couldn't find the answer. Now, add to that—
They said essentially that it's not only unknown, but it's unknowable.
Right. Add to that the fact that there are many statutes that authorize agencies to promulgate regulations that amount to crimes, and you have potentially thousands of laws out there. No lawyer, no judge, no law professor can know them all. And to make it worse still, many of them do not require that the government prove someone knew he was breaking the law in order to step across the line. If no reasonable person knows where the line is dividing criminal from civilly permissible conduct, people are going to step across it unwittingly. And that creates terrible problems, because you allow then for discriminatory enforcement. You can pick who you're going to enforce the law against. It also creates disrespect for the law. Normally, people think lawbreakers are people who know what the law is and defy it. They go ahead and they break it anyway. If people can unwittingly break the law, you lose respect for the law, because then the people who get arrested feel that it's more the result of happenstance than it is of intentional violation of a known legal duty. It creates a terrible problem for businesses, and particularly small businesses. If you're the CEO of Dow Chemical, you have an entire legal department, and you have lots of white shoe law firms on speed dial. If you're the local dry cleaner, you don't. Probably the only time you deal with a lawyer is maybe when you deal with a contract to get supplies, or maybe when you're getting your will done or something like that. Yet you can violate the federal environmental laws by, in good faith, trying to dispose of materials that violate regulations. Those people don't know what the law is, and yet what happens when you allow regulations to become crimes is you essentially force people to consult lawyers before they take certain acts. Neither the English common law nor American law ever contemplated that. Basically, the criminal law was designed to deal with conduct that everyone knows in his or her heart is harmful, is wrongful, and should not be engaged in. Granted, we no longer have a criminal code that parallels the Decalogue, but the criminal code we have today, buttressed by the regulations that have been adopted over the course of decades now, make it impossible for the average person to know what the law is. There are different ways of dealing with that. Former Attorney General Ed Meese and I have urged Congress to adopt a mistake of law defense that would exculpate someone if neither he nor any reasonable person would have thought that the conduct charged against him is a crime. That's one way to deal with it. There are others. But it's a serious problem, and this case typifies some of what can happen when you do that. If an agency is tasked with enforcing, the anti-nail law, and the only thing you give them is the hammer that you mentioned, then every case is a big case.
In that respect, the problem of overcriminalization through legislative means and through the proliferation of regulatory offenses becomes even more pronounced when you combine that with a very specialized law enforcement agency, because the disparity between the information available to the person, the citizen who is subject to those, and the very specialized agent who is in charge of those things is that much greater.
Absolutely.
Mr. Steed, BLM Rangers have a long history of contributing to the stewardship and the effective management of federal lands. Tell me how the job of ranger differs from that of the job of special agent.
So if I was going to make an analog to a traditional law enforcement, I would say rangers are more the uniformed police officers on the beat, special agents are more the detectives.
Can you walk us through the history of when BLM began hiring agents and how the number of agents and how they were equipped has changed over time?
So I'm unfortunately unaware of how that's changed over time. I can say that we have had a uniformed presence since 1978. Other than that, I can't provide specifics on the buildup. I'm sure we could follow up on that.
That's fine. What about today, setting aside the historical context? How are special agents today equipped differently than rangers?
I don't think that there's any difference in equipment. They may appear without the same brown uniform that you frequently see with the Rangers, but I think they're issued the same equipment.
Do the Rangers have flak jackets?
In some cases, they do, sir.
Do the Rangers have machine guns?
I don't know. I haven't done a full inventory. I can't say to this end. We're doing a full uniform review, as I said earlier in the testimony, as well as to figure out what equipment we need or which we don't.
I want to get back to a point Mr. Noel made a few minutes ago. I'll preface this question with the fact that BLM, I think you would agree, has suffered significant reputational damage due to its officers, its agents engaging in misconduct, and their overzealous use of some really heavy-handed tactics. Now, FLIPMA, as Representative Noel alluded to earlier, directs the Secretary of the Interior to delegate law enforcement on public lands to local law enforcement officials, quote, when the Secretary determines that assistance is necessary. Now, given the lack of trust that exists between local communities and BLM law enforcement, couldn't BLM really benefit in a lot of ways from having the help of local law enforcement officials, helping any federal agents who might be involved?
So 2 points. First of all, just to clarify, listen, I've been around the agency, interacted with a lot of our law enforcement personnel, and I just don't want to paint with too broad a brush. We have many good people working for the agency, people who care deeply about their jobs and put themselves in harm's way every day. And I'd be remiss in not acknowledging that. We have identified a handful of bad actors, and based on that, we're trying very hard to make those personnel actions.
I want to be very clear, Mr. Steed. I agree that that is true. That is absolutely true. But there is still a big difference between the fact that these things have happened within your agency. Federal land management law enforcement agents have done stuff that just wouldn't happen in Kane County, that just wouldn't happen in Garfield County or in any of the other areas represented by Representative Noel, in most of the other parts of my state and the Intermountain West. They just wouldn't happen like this. Or they would occur with far less regularity because local law enforcement officers have something in common. They are all accountable, either directly to the people, as is the case with many sheriffs, for instance, or to someone else who is accountable to the people. Perhaps it's through the local police department that in turn is answerable to a mayor who is herself elected. But these things just don't happen. Sure, there are other problems that might arise. No law enforcement agency is going to be perfect as long as it's run by mortals, and we don't have access to angels to run our law enforcement agencies. But it seems to me that the particular species of heavy-handed abuse is far more prevalent with a law enforcement agency like yours than it is with the, say, the Kane or Garfield County Sheriff's Office.
And I've acknowledged that we've had a problem. And in addressing that problem, I can do three things. I can address personnel, I can address proximity, I can address policy. As to personnel, I think I've mentioned that we're pursuing actively civil, criminal, and administrative actions against some of those bad actors. In proximity, we're trying to get law enforcement closer to those who we interact with and who we serve, which is why we're looking to move BLM law enforcement headquarters to the west. And in policy, we're quite active right now in reviewing all policies regarding our law enforcement. One of the first things I did in my current position with regards to law enforcement on March 3rd, I put out an information bulletin encouraging just what you're suggesting, to work closely with local law enforcement based on the unique attributes that local law enforcement brings to bear. I think we should do that, and I think we will continue to do that and increase our effectiveness in those collaborative agreements.
I understand it. I want to make very clear, I appreciate what you're doing and what Mr. Perry is doing. I appreciate your efforts in this area, and I appreciate the efforts of the many personnel who work under your supervision who are doing things right. As my late father, who like me was an attorney, used to say, especially when speaking to groups of attorneys, it's a shame when our entire profession is disparaged on the basis of only 800,000 or 900,000 bad apples. I'm sure the ratio, the ratio of reputational harm among these agents is more favorable within your agency than it is of the legal profession. But nonetheless,
as a member of the legal profession, can I take offense?
Right, right. My dad also had this little sign in his office that said, "Yes, I'm a lawyer, but don't tell my mother because she thinks I play the piano in a bordello." The point is, there are some environments in which certain people of certain professions are going to be more inclined toward misbehavior than others. This, as a very specialized federal law enforcement agency within a federal land management agency, it seems to me is particularly prone toward these types of missteps, notwithstanding the fact that most of them are very good people. It's just that the inputs are different. And I think that's one of the reasons why we ought to be concerned here, one of the reasons why FLIPMA favors, encourages, and arguably creates a strong presumption in favor of bringing in local law enforcement to assist with the day-to-day management of public safety issues on federal lands. And why it certainly wouldn't contemplate this, this army of quasi-militarized federal police handing out traffic citations to the tune of thousands and thousands a year, just because those citations happen to have occurred within federal land. On a related note, as you're aware, a federal judge recently declared a mistrial in the criminal trial of Cliven Bundy and his sons based on the U.S. Attorney's failure to produce exculpatory material before the trial. I'm sure you would agree that BLM-led standoff at the Bundy Ranch, out of which those particular criminal charges arose, was ill-conceived and was poorly executed. If BLM does law enforcement, doesn't it have a responsibility to set the tone for federal law enforcement down the chain?
In terms of the specifics on the Bundy the Bundy case, I can't get into it. There's an appeal pending, unfortunately, and at the risk of being prejudicial to those cases, I just can't get into it.
Okay, what about in the abstract? I understand.
In the abstract, absolutely, which is exactly why I say that we absolutely are trying to increase our accountability to the American people by having the right personnel at the helms. We're absolutely trying to change policy to make sure that we're as accountable and as responsive and as good at our job as possible. And I think if the secretary were here, he would tell you that this is one of his strong priorities as well. I mean, he doesn't want people to fear Department of Interior law enforcement. He wants people to see that they're out there trying to do their jobs and manage resources as FLTMA and other laws have encouraged.
Okay, but the judge's order in this instance said that the material related to the use of snipers, which BLM had denied aggressively. Isn't that the case?
Again, I can't get into the specifics of the case.
But I think I'm referring to an undisputed fact. I don't think that part of it's under dispute. If you've been instructed by legal counsel that you shouldn't answer, then far be it from me to tell you otherwise. But I would just say that to the extent that BLM isn't doing a good job of making sure that things are being handled correctly, not only within BLM but down the chain, and particularly where, as I believe to be the case here, BLM denied rigorously, aggressively, what had in fact happened. I think to that extent, in those instances, BLM law enforcement agents are failing to do their job appropriately. Tell me when the assistance of local law enforcement officials is not necessary.
Oh, I think that the default position should always be to incorporate local law enforcement.
And to the extent it can achieve that, it saves the taxpayer money.
Yeah, well, and I think if you were to look at our cases writ large, I mean, I recently read a report out of Alaska where on some BLM property we had auto thefts. Apparently, the investigation was conducted jointly with the local law enforcement regarding those. When it was a theft out of automobiles, arrests were made and prosecution sought in state court without ever involving that. And so I think there are many cases in which that type of relationship plays out on a day-to-day basis.
Mr. Larkin, let's get back to you. There is a bill in the House of Representatives that's been introduced by my friend and colleague from Utah, Congressman Chris Stewart. It's called the Local Law Enforcement for Local Lands Act. This is a bill that would eliminate criminal law enforcement offices of within BLM and within the Forest Service, and would use the funds saved by the elimination of those offices to provide grants to local law enforcement so that local officials within the area of lands managed by the Forest Service or the Bureau of Land Management could enforce criminal law, federal criminal law, relating to federal public lands. Is this an approach something that you would support based on my description of it?
Yeah, I have to say at the outset, I can't take a position in favor or against any particular legislation, so I can't say that is a good bill or a bad bill. What I can say is that it always makes sense to have local law enforcement involved. Why? Local law enforcement knows the people involved. There's a famous case that happened in the suburbs of D.C., where in Maryland, there were police that conducted a raid on a home and wound up shooting the two dogs, that were there. The police that did the raid never contacted the locals to find out anything about the people inside. It turns out the home was the local mayor, okay? And somebody what had happened is this is practice. It happens in drug trafficking. They will ship the narcotics to an unsuspecting person and say you can leave it on the porch, and then they'll come by and pick it up because if it gets intercepted en route, they're not responsible. It wasn't their home they were having it shipped to. So that's what they did in this case. They had it shipped to the mayor. And somebody found out about it. The cops conducted this raid. They go in and they treat the mayor like he's, a member of, a Colombian cartel. Well, if they had contacted the local police would have said, no, wait a minute, you don't need to go in this strong in this case. This is the mayor. Just knock on the door and talk to him, and he'll tell you. He's not, going to shoot you. You don't have to go in like you're breaking into a meth lab. It always makes sense to talk to the locals. Now, of course, there are exceptions where maybe if you're dealing with a public corruption problem, et cetera, you have to exclude the people who may be the object of the search. But generally speaking, in matters like the Red case and in matters like the one that I just mentioned that happened in suburban Maryland, you want to include the locals because if you're the feds, because they have a much better feel for the people involved, the community, et cetera. The case I mentioned earlier, the investigation I conducted of the physician who violated the environmental laws by doing an asbestos rip and strip, I worked with a police officer from Stanton who was one of the best cops I've ever worked with. And I couldn't have made the case without her involvement. And it is going to be the case, by and large, that you want to get the locals involved because they have more intel than you do. And they may even have more assets than you do because they have people that can be involved. So it is always sensible to try to get the locals involved if you can. If you're dealing with, like I say, a problem because the objects of the investigation themselves may be police or politicians, or if you're dealing with a national security matter where you may feel that you can't disclose the information surrounding the case to the locals who haven't the security clearances, those are different cases. Those are a very small number of them. By and large, you want to get the locals involved.
Going back to my earlier question, suppose Congress were to decide as a matter of policy and pass a law deciding that it was unnecessary or unwise for land management bureaucracies to control undercover criminal investigations or to execute search warrants or undertake raids or make arrests. Are there ways to organize those functions to ensure that federal law is still being respected on federal lands?
Yes.
So that would not be Armageddon. That would not produce an Armageddon type of environment. Dogs and cats living together in the streets, Book of Revelation stuff.
Yeah. No, I mean, if you want proof of that, this was created by FLIPMA, which was passed in the 1970s, for more, probably for 200 years, we got by without having a law enforcement program in the Bureau of Land Management and the Department of the Interior. If that was when it got started, everything that happened up till then was able to work with just state or local law enforcement or the Marshal Service or the FBI as need be. It wasn't as if all of a sudden there was some tremendous need just for law enforcement at a regulatory or proprietary agency. For a very long time, we got along without it.
Mr. Steed, following up on a previous question I asked to you in relating back to some of the other FLIPMA provisions that Representative Noel referenced. FLIPMA says that contracts must be offered, quote, with the view of achieving maximum feasible reliance upon local law enforcement in enforcing federal laws and regulations. Why do you think FLIPMA envisions maximum feasible reliance on local law enforcement?
Senator, I think that we can all acknowledge that local law enforcement has a unique tie to local communities that probably can't be replicated the same degree from a federal law enforcement perspective. And if I were to hypothesize on that, my guess is that those who authored FLIPMA certainly were nodding their head to that notion.
What would you say about, in response to the question of whether BLM is achieving maximum feasible reliance on local law enforcement?
I can tell you our intent is to achieve maximum feasible reliance on local law enforcement. I can't speak to the past. I can say that what we're doing here is trying to work very closely with our state and local partners and meet the needs that we face in managing public lands.
Representative Noel, I assume you heard my question a moment ago to Mr. Larkin about Congressman Chris Stewart's bill. What's your reaction to that bill?
I think this is the same bill that Congressman Chaffetz started on, and actually it was one of the bills that I proposed in the legislature. We've actually been able to, in the Utah State Legislature, limit what we call the assimilation of state laws, the traffic laws, et cetera. That bill went to federal court, and one of the judges ruled it unconstitutional, and we had to revise it, but it actually did go out. It's interesting. Mr. Steed talks about we wasn't sure what happened when FLIPMA was passed. I was actually working for the agency prior to FLIPMA being passed and when it was passed. And that was when it went from an agency that was disposing of the public lands and managing them for disposal to one of, we were now going to retain the public lands and ownership with an opportunity to dispose of land. Still, there was no thought at the beginning of that agency for federal law enforcement. There was never any federal law enforcement in the state of Utah. There was a special agent in charge, Marty and Skip, I can't remember their last names, but they worked exclusively with local law enforcement. I don't think we got a BLM ranger for probably 10 years into my BLM career from September 1976. And that agent was actually doing mainly resource protection things, someone stealing wood, someone trespassing cows. Even then, they used the brand inspector. So that was the way it worked then. And Skip and Marty would come down. They would work with local law enforcement when there were problems, and they would take care of the situation. When this first BLM law enforcement officer was hired, he didn't do anything in terms of ticketing or any type of thefts. He would work mainly on resource damage issues. In fact, the local sheriff at the time actually deputized him and made him a deputy sheriff along with his federal authority to be able to do and exercise the laws as a deputy sheriff, which I think is very appropriate. I think that's happened in other parts of the state of Utah. But then he's under control and the accountability. That is the whole key here, Mr. Chairman, is the accountability. The fact that when we see collusion with NGOs, this was some of the case with the Dr. Red situation. There's direct connection to an organization that wanted to see prosecution, and after 8 years when there was no prosecution, when this supposed $1 million black market was out there, I would ask the question, was any money recovered? No. It was simply a false narrative that was out there that this $1 million trafficking of artifacts was going on in San Juan County. It's not true. It's never been true. There may have been some sold, but it was very, very minor. So I think that's exactly the way things should work. I think we should, in fact, have local law enforcement. Again, the Forest Service has specific duties with fire suppression and being able to stop fire and timber harvesting and theft. But again, those could be handled mostly civilly and penalties and fines. And again, if you get into it, it's when they cross over. We have lots of times where even the Park Service will have a situation where there was a rape that occurred in Glen Canyon National Recreation Area. The people involved there at the park had absolutely no background to prosecute that case and to go forward and investigate that case. And when they got involved, the sheriff basically said, no, you're not going to do this. And they backed off of it. So if you have the right sheriff and the right person involved that said, we're going to do it. And it goes really back to the fact that what is your right as a citizen to have a jury of your peers, not a federal magistrate in some court 200-300 miles away when you get charged with a crime, not having to go to federal court and deal with the high cost of federal attorneys and what happens in a federal court. You go to your local court, you have a jury of your peers, you have an opportunity to go to court and to have an attorney, a local attorney, handle those things. This is a case that even if you're innocent, by the time you go through that process, you have spent hundreds of thousands of dollars. I know this personally, and my help with Mr. Lyman, who will soon be the representative, his entire case on that road trespass was based on a false premise on the road. And the federal judge would not allow the evidence to come forward. We went to the U.S. attorney. We showed him the evidence that the actual case file showed it was not a Title V road. It was an RS-2477 road. They just blew us off. And so the arrest, the investigation, all the things that happened subsequent to that should never have happened in the way that it did. It should never have happened. It would never have happened. This is something I would like to see happen out of this. Again, any of these cases that were prosecuted and ended up in people going to court, they should be allowed to have those cases relooked at and the evidence brought forward in a manner that would actually show the true story. It goes back to what Senator Hatt said to Loretta Lynch with the Ted Stevens case, and he held up the book, License to Lie by Sidney Powell, and what happened to Ted Stevens, Senator Stevens, in his case, when he was eventually exonerated after years and years and years. But he said, I want you to read this book, because just like my friend to the left here said, you don't even know the crimes that are in there. You don't even know what you have to go through. It's all based on how many convictions, how many people get prosecuted, how many go to jail. And then when you get out, then you can go to work and say, hey, I can get you out of jail because I was able to put all these other people in jail when I was a federal prosecutor. So it's a system that's broken, and we are facilitating it in Utah by the Federal Land Policy Management Act and having federal law enforcement stepping into areas and arenas where it should be a state court, it should be local law enforcement. And that's my main purpose of flying from China it was actually at 8 in the morning. I left from Seattle last night and got here and went to bed at 1 o'clock in the morning because I wanted very much to get this on the record. It's a huge problem in the state of Utah and in the West. And I really appreciate you, Chairman, to bringing this forward. It's something we've got to solve. So I support Chris Stewart's bill.
Thank you very much, Representative Noel, and I appreciate your making the trip and providing your very significant perspective and your unique perspective as someone who has worn a number of different hats, all of which are relevant to this topic. I've got one final question for Mr. Larkin. I'm not sure you'll know the answer to this question. I don't, but it's something you said earlier piqued my curiosity. You referred to the fact that in the first set of criminal laws passed by Congress at the time of the founding, there were, I think you said, a few dozen, maybe 30 federal criminal statutes. Do you know how those were typically enforced at the time? Did they didn't have the FBI then. They didn't have a swarm of federal officers then. How were those typically enforced?
My belief is they probably were enforced by people in the Customs Service.
Okay.
That is, if you're dealing with the laws that made it a crime to cheat the government out of customs duties that it was due. To the extent you had it a crime to assault a federal judge or the like, those would have been enforced by the Marshal Service. Because the Marshal Service and the Customs Service were effectively the first law enforcement agencies the federal government had. And the Marshal Service was the equivalent of the sheriff's departments, if you will, that they had in England and that we continue to have in this nation, particularly in your neck of the woods. So that would have been my understanding as to how those would have been done. The Secret Service didn't come into existence until after the Civil War, and that was really at the outset to address counterfeiting rather than provide protection to the president. The FBI was the Bureau of Investigation initially, and then later became the Federal Bureau of Investigation. What we had since then, unfortunately, is the development of various different federal law enforcement agencies without Congress or the president ever taking a look back to see how best this should all be organized. You know, is there jurisdiction that one has that actually is better with the other, et cetera, and the like? I mean, we have two different types of protective services, three actually, if you will. The Secret Service protects a limited number of people like the president, foreign heads of state, et cetera. We have a diplomatic security service that protects people from foreign governments at the next level down. And then the Marshal Service protects people if there are particular individuals, say the federal government, who are at risk. But Congress hasn't ever stepped back and said, we've got this entire fleet of criminal investigative agencies out there, and maybe it makes sense to consolidate or move things around. So it's a very long-term project. But it's one that I've always hoped that somebody would take the laboring oar on, because the public would be better off, I think. And I think it would also help address the over-criminalization problem, because like I've said, when people have the full range of wrongdoing to look at, they get a better perspective on what is and is not important. So the overall organization of federal law enforcement has been a haphazard development. I think it's something that Congress and the president should look at. But like I said, to answer your question, I think with respect to violations of the customs laws, it would have been Customs Service agents. With respect to the federal courts, it would have been the marshals.
Thank you. That's a helpful perspective. It seems to have been something of a one-way ratchet with federal authority. And I think, as you say, it's important from time to time to look at whether what we've created makes sense. And it's one of the reasons why we have oversight hearings like this one, is because I think Congress needs to do a better job of providing oversight in a big picture view with regard to what we need and where resources might be better spent elsewhere. Okay, a couple of housekeeping items. I've got a statement for the record that's been submitted by Senator Lisa Murkowski from Alaska, who happens to be the chairman of the Senate Energy and Natural Resources Committee, of which this hearing is operating as a subcommittee. That will be admitted for the record without objection. I want to close by pointing out that I think we all seem to agree, based on our discussions today, that there should be more local law enforcement involvement in this area. I haven't heard any disagreement to that point. So I think that's a good point of agreement or relative consensus that's come out of today's hearing. The question that remains, as I see it, is whether law enforcement authority for federal land management agencies are, by their nature, so wrongly placed, or at least situated in such a way that they are so prone to abuse that Congress should consider amending or perhaps revoking their authority. That is a question that I think needs ongoing discussion. But today's hearing has been very helpful in exploring this issue, and I really want to thank each of you for coming and for the very valuable testimony that you provided. Seeing that there are no additional questions, I will indicate that members will be allowed to submit written questions while the record remains open. The record will remain open for an additional 2 weeks. And this hearing is hereby adjourned. Thank you.